Let's start. This appeal is directed against the judgment and award dated on 20th May 2005 passed by the learned Judge Motor Accident Claims Tribunal and Additional District Judge Kontai in connection with MAC case number 108 of 2000, whereby the learned judge dismissed the claim petition para. The claim petition under Section 163A of the Motor Vehicles Act 1988 was filed by one Shashanko Das for sustaining injury in a motor accident occurred on 20th August 2000 at about 3 p.m. at Kontai, Midrapur Road by the involvement of one bus bearing registration number WB310433. According to the claimant injured on that day, he was traveling in the bus as a passenger and the said bus capsized due to rash and negligent driving at the time of the accident. He was aged about 34 years, having income of rupees 4,000 per month. After the accident, Kontai Police Station case number 185 of 2000 dated 21st August 2000 under Section 279/338/427 of the Indian Penal Code was started. That is why the claimant injured filed the claim petition with a prayer for compensation to the tune of rupees 1 lakh para. Owner of the vehicle did not contest the claim petition, but the United India Insurance Company Limited contested the case by filing written statement denying all material averments in the claim petition, contending inter alia that the claimant, being not a passenger of the bus, is not entitled to any compensation. As a prayed for to prove the case, claimant examined as many as 2 witnesses, namely claimant himself as PW1 and one Prafullo Kumar Jana was examined as PW2. In course of their evidence, certified copy of the first information report, charge sheet, seizure list and discharge certificate were filed and marked as Exhibit 124 para. After analyzing the evidence on record, the learned tribunal came to its finding that the claimant could not prove that he was a valid passenger of the bus, and also evidence of PW2 cannot be taken into account, who was not a passenger of the bus and he could not produce the bus ticket. However, the learned tribunal did not believe the evidence of either PW1 or PW2 with regard to the injury sustained by the claimant and accordingly dismissed the claim petition para. Mr. K. Bonik, learned advocate on behalf of the appellant of the claimant, has submitted that the evidence of PW1 together with the discharge certificate within bracket Exhibit 4 proved the factum of accidental injury sustained by the appellant of the claimant, and he was treated in the Kontai SD hospital. Though no disability certificate has been filed in this case, but Mr. Bonik has relied on a case of Northwest Karnataka State Road Transport Corporation versus MS and another reported in 2002 ACJ 215, wherein the Honorable Apex Court granted compensation to the tune of rupees 1 lakh in absence of any disability certificate para. Mr. MP Chakraborty, learned advocate on behalf of the respondent number 1 of the insurance company, has submitted that no disability certificate has been filed in this case, so compensation cannot be computed towards the pecuniary loss para. From the FIR charge sheet and seizure list Exhibit 1 to 3, it appears that on 20th August 2000, accident took place by the involvement of one bus bearing registration number WP31/0433, and the accident happened due to rash and negligent driving of the bus, which capsized ultimately and passengers sustained injury. We should keep in our mind that in a case of motor accident, appreciation of evidence cannot be considered as evidence in civil and criminal cases in terms of principle of beyond reasonable doubt or preponderance of probability. In our case, PW1 has stated that he, being a passenger, sustained injury on the alleged date of accident, and PW2 has also stated in his evidence that passengers of that bus sustained injuries, and yes, thus that is the claimant of this case was one of the passengers of the said bus, and he also sustained injuries at the relevant point of time. PW2 was sitting in a shop which was also damaged by that accident para. Such evidence of PW1 and PW2 has been further substantiated by a certificate issued by the superintendent contained SD Hospital, Midnapur, wherefrom it is seen that he was admitted in the hospital on 20th August 2000 with a history of RTA on 20th August 2000 at about 15 hours, and he sustained multiple injuries and fracture over knee joint within bracket right, and he was discharged on risk bond on 22nd August 2000 para. It is true that the relevant doctor was not examined in this case, but overall evidence adduced on behalf of the appellant of the claimant together with the documents, I find no reason to disbelieve the injury sustained by the appellant of the claimant in the accident happened on 20th August 2000 by the involvement of a bus bearing registration number WB 31/0433 para. In spite of that, I am unable to hold any disability on the person of the appellant of the claimant in absence of any document to that effect, but considering the injury sustained by him, I find it justified to award a compensation of rupees 50,000 along with interest at the rate of 6% per annum from the date of filing of the claim petition, that is on 19th September 2000, till the deposit of the amount para. Accordingly, the respondent number 1 of the United India Insurance Company Limited is directed to deposit the compensation amount of rupees 50,000 along with interest at the rate of 6% per annum from the date of filing of the claim petition, that is on 19th September 2000, till the actual deposit of the amount before the office of the learned Registrar General of this court within 6 weeks from the date of this order. In the result, the judgment passed by the learned tribunal in MAC case number 108 of 2000 stands it aside the appellant of the claimant is entitled to withdraw the compensation amount with interest. The learned Registrar General is requested to disburse the amount with interest to the appellant of the claimant on proper identification and proof para. With the above observations, the appeal being FMA 837 of 2005 is disposed of all pending applications if there be any stand disposed of. Records of the learned tribunal along with a copy of this order be transmitted back immediately para. Urgent photostat certified copy of this order if applied for be given to the parties upon compliance of necessary formalities. Stop para. Thank you. Jai Hind, Jai Mera Bharat. Per annum from the date of filing of the claim petition, that is on 19th September 2000, till the actual deposit of the amount before the office of the learned Registrar General of this court within 6 weeks from the date of this order. In the result, the judgment passed by the learned tribunal in MAC case number 108 of 2000 stands it aside the appellant of the claimant is entitled to withdraw the compensation amount with interest. The learned Registrar General is requested to disburse the amount with interest to the appellant of the claimant on proper identification and proof para. With the above observations, the appeal being FMA 837 of 2005 is disposed of all pending applications if there be any stand disposed of. Records of the learned tribunal along with a copy of this order be transmitted back immediately para. Urgent photostat certified copy of this order if applied for be given to the parties upon compliance of necessary formalities. Stop para. Thank you. Jai Hind, Jai Mera Bharat. This order if applied for be given to the parties upon compliance of necessary formalities. Stop para. Thank you. Jai Hind, Jai Mera Bharat. Jai Mera